Good morning and welcome to the David and David on Real Estate Podcast. We are today on episode number 160. David, what a big round number. Always a
Yeah,
pleasure to be co-hosting with you.
yeah, good round number, 160 episodes. That's we're getting right up there. It's great. It's always fun, and today we get to talk a little bit more law, which is always great for me. I always enjoy doing it. I know there's a case that you wanted to bring up today for our discussion, so happy to dive into it with you today, David.
Yeah, I love these because there's a lot of different issues that are illustrated, and we talk about these all the time. But to see something go through the court system and hear the interpretation is always fascinating me. So why don't we jump right into this one?
Yeah, so today we're going to talk about a recent Ontario Superior Court decision called Graf and Periyathamby. Excuse me if I'm not pronouncing it correctly, but it doesn't really matter who the parties are, on these decisions. It's what we're going to learn from these decisions. And basically this was a situation where, where ultimately the issue was, did an agent get themselves into some hot water here because they were trying to act on both sides of a transaction? And here we were in a situation where there was the buyer was really trying to buy a restaurant, but in order to, so it's a business transaction as much as it's a real estate transaction on the one hand, but in order to be able to finance and buy this property, through this agent that they're using, this potential purchaser of the business had to sell two income properties that they had, so to use that to then finance it. So as it turns out, the same agent was representing the buyers of these income properties and not disclosing all this information to everybody that, hey, I'm the same guy, I'm helping to purchase business, but I'm also helping to sell these income properties, but I'm acting for the buyers of the income properties who happen to own the restaurant that on the business transaction. So it's a sort of a crazy fact situation. I don't know if I left anything out, David, but I think that's sort of what happened here.
Yeah, it's a full 360, right? So the sellers of the restaurants are now the buyers of these income properties. The buyer of the restaurant needs to sell these income properties in order to qualify for and have sufficient funds to be able to purchase a restaurant. And I believe that the agent who's representing all these parties failed to make proper disclosure.
Yeah, and so it happens to be the one agent is acting for everybody here and not telling everybody that, and not disclosing to everybody that that's what they're doing, and trying to help everybody do it. And I think they even led the purchaser of the restaurant to believe, or I think no, someone related to the agent was also part of the transaction as well, and it wasn't disclosed. So, anyways, at the end of the day, these deals fall apart. Okay, they can't close. So instead of it just being, an issue between buyers and sellers on these transactions, and sort of everything turns on the agent, because the agent didn't disclose, and if anybody suffered damages here, it's the agent's fault because the agent didn't provide full disclosure. Because and it's not just a question of providing disclosure, that's part of it, but there's a real conflict of interest that arises here, because you can't in good faith negotiate for one side and then negotiate in good faith the other side when there's competing issues, which begs the question, I think, David, like, why do a double end on any deal? Because it's only potentially going to get you in so much trouble. And I discourage agents from doing it all the time. And I know it's so tempting. And I just did one the other day on a residential house. And the agent sent it to me, and he says, I'm double ending these deal, and I need you to review this agreement, for the seller. And the buyer's got their own lawyer. And I'm going, but is this a good idea for you as the agent to really be double ending this deal? Because if something goes wrong, you're going to be the one everybody's going to turn to and say, you didn't tell me this. You you had information from the other side, wasn't disclosed to me. If the deal goes bad, the easiest place to look at is for anybody that has a potential conflict of interest. Okay. And why put yourself in that situation? Like if everything goes well, great. You're going to get commissions on both sides of a deal. In this situation, if everything went well, this agent could have had lots of commission because he's on, he's getting paid on the business transaction, he's getting paid on the income properties being sold. So great, but it's complicated, and then there are issues. Purchase of and sale of a business has its own issues. Purchase sale of real estate, there's always issues that come up, and you have a duty to disclose everything and not hide anything. And it's a real easy thing when the deals go bad for someone to point their finger at anybody that had a conflict of interest or a potential conflict of interest. So
Yeah, I mean, it's the first place you're going to look at. It's the weakest link, right? So if you are double ending a property, you better make sure that everything is 1000% done correctly and that there's nothing that could possibly be pointing back towards you. Otherwise, you are the weakest link and you are going to get the brunt of the story. And it's not a great situation to be in. So I discourage realtors from double ending properties if they are not 1000% sure and above board and know exactly what they're doing every single step of the way. And your biggest motivational factor should be the best interest of your two parties. And of course, that term has different meaning in multiple representations because you have limited uh, fiduciary duties to both parties, and there's certain things you can and cannot disclose, and certain things you can and cannot do in order to protect both sides and maintain that impartiality as the agent that's representing both sides of those transactions. And the other thing is both sides need to be, they need to understand what those limitations are. They need to understand that you have limited fiduciary duties. They need to understand what those limited fiduciary duties are. They need to understand what you can and cannot disclose. They need to understand exactly what your role is as a double agent, right? So if you can follow those steps and make sure that the agreement is 100%, all the technicalities are done 100%, that you've explained multiple representation, that they've consented to multiple representation, and that they understand what the limited fiduciary duties are and the limited disclosure duties of both sides, then you have, a good blueprint of how to move forward to. But there are a lot of complications, and it is very, very difficult to navigate multiple representation situations correctly, and not put your interest out there. You have to put your client's interests ahead of you in order to facilitate the transactions.
right, and you're just putting yourself in jeopardy with non-compliance with your RICO obligations, which starts in a multi-representation by the simple like you can't do it at all unless both sides consent in writing for you to do it. And you can't get to the consent without giving them the full explanation and being transparent about who the parties are and what the situation is and what your role is going to be and your duty to disclose to everybody. You have to go through that with them and make sure that they each, not only did that you told them, but that they understood it and that they agreed to it and they've consented to it in writing. And you've got to have that. And then even if you do all that, there's still the potential if the deal goes bad, and even if you did all that, they're still going to come after you and say that you left something out or they didn't really they signed the consent, but they didn't really understand it. They didn't take it to a lawyer. They didn't get independent legal advice on it. They weren't really aware of the risks. They just you just told them to sign a bunch of stuff, so they just signed it, and you didn't give them full explanations. So you're opening yourself up to those possibilities. When the deal goes bad, they're coming after you. It's the easiest place to do. No difference in my like in my profession. There's certain situations where we can act on both sides of a transaction, and we're allowed to do it as long as we provide certain disclosures. Same things, get the consent of parties. And certain things we're allowed to, certain things we're not allowed to. But even when we're allowed to, the question is, well, should we? Is it in our firm's interest to do it? Why should we expose ourselves as a potential, $900 fee for doing it, but the exposure is worth, like 10 times that, 100 times that. Is it worth it for that amount? Or are we better off to not take that risk, refer them to another lawyer to act on that side of it, and then just try and get the transaction closed? Like, why take that risk, even if you're allowed to take that risk? Is it worth it for that additional legal fee? Is it worth it for that additional commission when you put yourself so exposed? Okay. And this was a complicated transaction, because it's a business transaction, and then there's these other income properties. So there's a lot of moving parts to it. But even in a very simple, basic residential real estate transaction, you really should think long and hard about whether it's in your interest to double end a deal. Okay. Um, because things do happen, especially these days. Transactions don't close for various reasons. And it could be as simple as the buyer can't get their financing or can't get enough money on closing. Now the deal doesn't close, and now the buyer needs more time, wants an extension. Seller doesn't want to give it. Now you're in a conflict position if you're on both sides, because what kind of advice are you going to give the buyer? What kind of advice are you going to give the seller? Who are you helping out more? You just put yourself right in the middle of it. So instead of becoming an issue between the buyer and the seller, it now becomes an issue that everybody's looking to the agent that has a conflict. So,
Yeah, 100%. And your reputation is also at risk here. Like you have to have a lens of what that looks like, 10, 15, 20 years from now, right? And you don't ever want to be in a situation where a client challenges your reputation or puts a bad review or stains your reputation in any sort of way. The $20,000 or $30,000 commission check is not going to be worth it in the long run, right? So having that bigger picture point of view and really looking at it, can I really provide the best fiduciary duties to my clients if I'm representing both sides? And
right,
you can't. You can provide limited fiduciary duties at best. You can't provide full fiduciary duties. And at the end of the day, you have to ask yourself, is tainting your reputation worth it in the long run?
right. And even if you think you have sophisticated clients that do many transactions and know what they're doing and understand it themselves, it doesn't matter when the what hits the fan, they're coming after you because it's either there's a conflict or there's a potential conflict, and you're just an easy target for them to go after, and clients will turn on you in a second. And we see it in your business all the time. We see it in my business too. If things go bad, it's never the client's fault. It's their agent's fault. It's their lawyer's fault. It's their broker's fault. It's somebody else's fault. And they're looking for everybody and anybody to sue. And sometimes the advice they'll get from a litigation lawyer, okay, would be, well, you know what? I looked at this. Your agent didn't really do anything wrong, I don't think, but let's sue him anyways. And you know what? Your lawyer, I don't think did anything wrong, but let's sue him anyways because we can go after their insurance and just put some pressure on them to try and settle. And even though they probably didn't do anything wrong, if it goes all the way down to court and a decision, they might be fined, that they're not liable for anything. We might get a settlement out of them or out of their insurers. We might get a settlement. So let's sue them and name them anyways, even though we think it's a bunch of bull and we don't really like to, but we might get a some and insurance companies pay out on these things.
Of course they do, because it's a business decision.
Right.
$100,000 in legal fees, even though you're not guilty, and even though you're probably going to get a judgment saying, hey, you know, the other party has to pay my legal fees, but try to collect that. It's time, effort, money. So they make a business decision. Listen, we have to write a check for $50,000. We'll just write it. And
Mhm.
it's easier to handle it that way, right?
Right.
So I love hearing from agents, oh, this person is my best friend. They would never put me in that situation. When the what hits the fan, they're going to follow the advice of their litigation lawyer. If their litigation lawyer is saying, hey, listen, they have a cushy insurance policy that we can lean on, guess
Right.
what? You're getting dragged into it no matter what your relationship is with that client.
Right. And we're likely to be able to get some sort of settlement out of them. And so let's just name everybody and see who wants to settle and where we can
Yeah.
get money out of. Because we might not be able to get money out of the other party to the transaction. They may not have resources to pay any damages, even if we're successful. But if we make a claim against these, the agent and the lawyer who've got insurance backing them up, we know there's money available from the insurers. And even if they think they've got a good case, most of the time they're gonna look to settle it. They're only going to settle it by paying something. So let's go that route, and they do it all the time. Which is like, something I mentioned on our last episode we did on a case where, where I think the facts are pretty clear. And I'm sort of mentioned to you in our last, like, I'm surprised this actually goes all the way down to a court decision. But maybe it did because that's the advice they got on the litigation was, I like our chances, let's keep going because we'll probably get a settlement. And in that one, just, they never did get a settlement and they got and a decision went bad against them. So now and you know what, that party that lost on that litigation, they're going to look to go after their lawyer for litigation lawyer for giving them bad advice. Because now they didn't get anything, they didn't recover any damages, and they got to pay their lawyer's legal fees. So, you got to be careful in these situations. But to me, the easiest thing, when anybody wants to double end a deal, my initial reaction is like just don't. Like it's just, I know times are tough and it's really tempting. And I see it even in transactions. Well, the buyer and the seller know each other, they're related or something. So, maybe in those situations, it's a little bit more tempting to do it because there's
But
less
David,
likelihood of them turning on each other.
I would argue the opposite. I think if you're related to a party, I think it's easier to step back and have, a neutral party in between those two parties in order to make sure that everybody's interest is protected. I think if you're related to a party and you're trying to double end, I think that's when it's really hard to control your emotions and represent both parties adequately,
Yeah.
right?
It's true. Issues come up on those two. Like I just did a deal recently where, it's a purchase sale between related parties, great relationship, and they draft up a private, agreement, between them, and they didn't put in, a proper list of chattels. And they say, okay, look, how come there's no fridge and stove and that's included? Are they all coming out of the property? Oh no, no, we meant, we assumed we were getting all that. Well, but it's not in there. And then the seller says, no, no, I wasn't planning on leaving those. I'm pulling those out and I'm going to sell them separately. And I go, what? Um, all of a sudden, these two relatives aren't in agreement as to what they thought they were getting. But what the buyer's going to get is exactly what was on paper, which was no appliances,
Oh,
right?
wow.
So, unless they agree to an amendment, but now there's a fight between them because they didn't have the proper advice of an agent or a lawyer, dealing with this when they were drafting it up. So, there's all kinds of scenarios where you could see yourself getting in a lot of trouble. And even that, we assess that too, because sometimes, on a private transaction like that, we're not using agents. I'm selling it to my relative. Can you guys just draft an agreement for us and act for both of us? But we got to be really careful to do that. And it's like, no, I don't really want to do. I'll draft it up for one, but I'd rather the other party go get independent advice from another lawyer because if I'm drafting up and saying no chattels are included, let somebody else give you advice about whether the chattels have to be put in there or not put in there, right? So like, why would we take that risk? So we generally choose not to. So my advice to any agents out there is think long and hard about ever double ending a deal because it's probably like it's just not worth to me. It's not worth the risk reward thing doesn't work for me. But if you're going to do it, right, David? Like you said, you've got to make sure you go through all the proper steps and comply with all your RICO obligations of full transparency and disclosure and getting it signed off and making sure you got evidence of all the explanations and the detail and everything. And you got to spend all that time and make sure you're doing it right. And then when an issue does come up, you got to make sure they've got proper legal representation separately and everything. And they got to understand that you're out of it. You can't help them resolve those issues because they have competing interests. Um, so you make sure you do it properly. But I think the first advice, if they come to you, David, as the owner broker there, like what are you telling them?
Well, I'm definitely pointing out all the risks, right? And I'm guiding them through the process. And ultimately, they have to make the right decision that's right for them and for their clients, but they have to know exactly what's involved every step. So we really like to be involved in these situations, and we really like to give our agents the proper guidance throughout the whole process.
Yeah. And it might be you tell them, you're better off to refer one side of this to another agent in the brokerage. And even then, you've got to be careful if it's within your own brokerage, about disclosing and how that works, as opposed to them referring to an agent that's from an outside brokerage, which is different. Um, but they've got to make sure these things are addressed properly because it's a potential landmine.
Yeah, and I mean, with designated representation, it does get a little bit easier referring within the brokerage, but there's still a lot of different considerations that agents and clients have to make, and proper consent and proper disclosures is at the heart of multiple representations. So, I think agents really need to think clearly before making that decision. And if there's any sort of level of complexities to this, then referring out to another agent is definitely the best way to go. And in the case that we were discussing, not only is there, there's so many different complications, and like that one realtor would be double ending basically three transactions, so six different ends on two of the same clients. Like, really hard to protect anybody's best interest. And at that point, you're just basically pushing paper and trying to get the transactions to come together. It's a tough situation to be in, and clearly all sides weren't aware of who the buyers are and what the representation was. So it's no surprise that this went sideways when everybody sort of found out what is really happening here and what's at stake. So really, again, another situation where it kind of just showcases how important proper disclosure is, and how important, making sure that you represent and have fiduciary duties to your client, and what that can really entail in the grand scheme of things.
Yep. So, the only thing that would have made it worse is if they had the same lawyer acting on all sides of these transactions too. But you think the lawyer looking at this would say, no, no, I can't do that. And and lawyers too, like, on the business transaction, the lawyer would never normally wouldn't be acting for both the buyer and the seller. A residential transaction, they shouldn't be doing it either. But the same thing for the agents. It's just not worth it. The agent should have known better. And when things go bad, it's the agent left being responsible for paying damages in this case, and rightly so. I hate for any award of damage to go against anybody, but the agent should have known better, and the agent should have done better. And by them not doing so, the agent breached their duty to their clients and is the one that should be responsible for damages. So I think it's the right decision. I don't know if it's going to be appealed at a higher level, but I don't like their chances
No.
on anything. So the agent should have known better and should have done better.
100%. Guys, reach out to us if you have a difficult situation, if you have a question about representation, if you've been in a multiple representation situation that you want our advice on. Please send us an email. We'd love to hear from you. Thanks for tuning in, everybody. Practice in a professional way. Stay safe. Disclose all your conflicts of interest, and have fun out there. Thank you, everybody.